Hi everyone, welcome tonight. Thank you for coming out. My name is Cristin Lowe and I am a divorce attorney, and tonight we are going to be going over all of the divorce forms that you need to get started in the divorce process, and we are going to be helping you. And the reason why we're doing this for you for free is because we love what we do. I really enjoy being a family law attorney. I enjoy helping people through a really difficult time in their lives, and when I go to the courthouse and I see people struggling and trying to get through the divorce process on their own, it's really hard, and I can't help everybody with their divorce, but I'm hoping that by giving seminars like this that I can help more people than I do right now. So I hope you're comfortable. The reason why we're doing it here instead of at the courthouse, first of all, budget cuts, there's no way they're open tonight. And second of all, we have a little bit more updated equipment and technology than they do, so you don't have to deal with the 60s projectors. All right, so we have our person set up. I have pulled an innocent victim out of this audience, and they're going to be helping me type the forms just to show you that anyone can do it, and it is accessible and it is doable. So we're just going to do this real time, and mistakes and all, we're going to keep going. So if you have any questions, and I know it's hard and this might be a little bit embarrassing to be asking your personal question to everyone here, so you can talk to me afterwards. If not, give me a call afterwards. If you need to email me, let's do that, and we'll make sure everybody has my contact information. And then with that being said, let's get started. Okay, so we are now going to answer the question, what happens if I'm the one that's been served? What do I do now? I've been the one that's gotten that summons. What do I do? Okay, so that is that response, which is form FL-120, FL-120. So let's go to commonly used forms. And I know I said this before, and I can't say this enough. California is a no-fault state. It doesn't matter if they're the petitioner or the respondent. And I know I have a couple respondents here today, and I'm sorry if you were served in an embarrassing manner. All I can tell you and help you with here is try not to do the same to your spouse. You don't have to make this a big deal. I'm sorry if they were spiteful, but moving forward, keeping your kids at the focus of it, that's really going to help out in this situation. So let's go to form FL-120. That's called the response. Okay. Now we are no longer with Jamie, we are with Dale Smith in our response. Think of the response and the petition are two sides of the same coin. You will notice when we go through this form that you're going to have a lot of very, very similar questions. In fact, identical questions. This is the respondent, or in this case Dale's, opportunity to be able to answer the same questions the petitioner did. So the number one thing to remember is this is the respondent's. This is your personal response. You do not have to mimic or mirror or agree with anything the petition said. It's nice if it matches up, but it doesn't have to. This is your opportunity to tell the judge your side of the story. Okay, so it's going to be the same as petitioner or respondent in that we always have a caption, but this is the first time we're doing anything on Dale's behalf. So we're going to put Dale Smith at the top. So Dale is the respondent, and Dale will always be the respondent, and we need an address for Dale. And we can even pretend that Dale and Jamie still live together, but we're going to have them live separately. Same caution or same advice that I would give to a petitioner or respondent: make sure the mailing address is a good mailing address that the court can reach you at and that your spouse can reach you at. The reason for that is because once this response has been filed, it's considered that both people are actively involved in the case at this point. What does that mean? It means that we don't have to do personal service anymore. Things can get served or sent to the other side by mail. So if you have an outdated mailing address, guess what? It can get mailed to the old address that's considered valid service, and you wouldn't know what's going on. So keep your address up to date. All right, same thing with your phone number. If a court clerk needs to reach you and you never check your voicemail, then maybe you need a landline, or maybe you need some number where you're always going to pick up. Okay, same concept. Attorney for, in this case, Dale, is in pro per, and that means self-represented. Same information, County of Contra Costa. We're at 751 Pine Street, P.O. Box 911, Martinez, California, 94553. And you are not the petitioner. And I keep saying this, but I do mean it, because a lot of people do mix it up. They say, oh, well, I'm filing, so I need to be the petitioner. No, you are always the respondent once you are the respondent. So the petitioner in this case is going to be Jamie Smith, and respondent is going to be Dale Smith. Respondents, You don't get out of jail free here. You always have a case number. The petitioner won't have a case number because he or she hasn't brought the documents down to court. However, the respondent has been served with the papers. So for those people who are the respondents here, you want to grab your petition, the documents you were served with, and you'll see a case number. You're always going to use that same case number. All right, so let's keep going down. We're going to have a response, and in this case, we're going to say that Dale wants the divorce. So she's going to respond, or he's going to respond, check the box, response, and then check the box also for dissolution of marriage. Dissolution of marriage, the fancy term for divorce. Residence. Now, in our petition, we said that Jamie had been a resident of California for at least 6 months and in the county for at least 3 months. If Dale is also a resident of Contra Costa County and of California, then Dale can check the box respondent saying that they've met the residency requirements. So let's put that for Dale. All right, so date of marriage, hopefully that matches up. Hopefully everybody knows their date of marriage. And that's January 1st, 2000. And then we're also going to take a date of separation. So this is an example of where maybe the date of separation might not be the same. So let's say that Dale doesn't agree that January 1st, 2014 is the correct date of separation. Maybe Dale says that it's January 15th, 2014. That's okay. We don't have to have it all match up. Okay, but in this case, it's still the same. It's 14 years and 0 months. The date of separation is a really kind of tough concept for a lot of people, but it's the date that you feel that the marriage was over. And a lot of times that does differ because it's your subjective opinion. The date of separation, however, is legally very, very important. What does it mean? It means that the date that the assets separate. So we talked about this in the petition. So for those of you watching at home and you don't know what the difference between community property and separate property is, go back and watch the video in the petition and we talk about the community property versus separate property. But in a nutshell, community property is anything acquired during your marriage, from the date you married to the date you separate, and separate property is everything you got before you were married and since separation. All right, so the minor children, in this case, we used 2 minor children. The minor children were Susan and Robert, and we had birth dates for them. Then we have their ages and we have their sex. And children in the marriage, again, children born to, in this case, Jamie and Dale. Whether it was before they legally got married or during the marriage, it doesn't matter. We want to list all those kids. If they had a 3rd child, and let's say that was, I don't know, John Smith, and John is now 19 years old, we wouldn't list John on there. So we have Robert Smith as the other child. And we have a birth date for Robert. I think he's 13 if I remember right. So I'm going to be going over this form a lot more quickly than the petition, just mostly because we asked the same questions. So let's keep scrolling down. Separate property. And we're going to check the box below. If you are one of those people who doesn't know whether or not you have any separate property or you don't have a lot of separate property, you can put something very generically down. So I'm going to give you the language that I use when there isn't something very specific. And in that box, I will put all items acquired before marriage and after separation, comma, and those items, let's go down to the next line, acquired, there's a C there, go, by way of inheritance or gift. And then under, period, sorry. And then under confirmed to, I would just put acquiring party. So what did I just say? I just gave you the definition of what separate property is. Separate property is anything you got before marriage and after separation. And we have a presumption that if you got an inheritance or a gift, that's considered separate property as well. And acquiring party means whoever got it should be able to keep it. Okay, so we're going to go down to page 2. And just like with the petition, we're going to start off with the community property on page 2. And it should be auto-filled. You need to pop in whatever the case number is. So we're going to put 5B, and we're going to check the box below. Check the box. There we go. Okay. So with Jamie, Jamie had listed out the house and the bank accounts and the retirement accounts. And we're going to do the same thing here. So we're going to say that Dale acknowledges what all the community property is. So we had the real property located at You don't have to. And do you remember the address you used before?
It's not the 123 Main Street.
I think you put something else there.
Okay. We can fill that in later.
Okay. So I think it was like 333.
So we'll put this, is this going to be on the internet later?
Yes. Okay, so we'll fill that in. So basically, in addition to the house, we would put in everything else they have. So like in the petition, we would put the household items, appliances, and furnishings. We would put the bank accounts, the vehicles, the retirement accounts, life insurance policies, credit card debts. If you had other debts like tax debts or debts owed to your parents, you put that down as well. Again, I don't need specifics. I don't need a Vanguard account 1, 2, 3, 4, Fidelity account 5, 6, 7, 8. I don't need to know all of that, but we want to give the judge at least an idea of what property is out there. Okay, so I'm going to say the respondent, and we're going to skip 6 and 7 because those are legal arguments, and if you want to make those arguments, you'll want to talk to an attorney, so please call us, and then we will be able to help you more specifically. But that's definitely a fact-specific issue and a fact-specific question. So let's go down to number 8, and we'll check the box A and 1. Same thing, irreconcilable differences. Non-incurable insanity, I'm sorry, as crazy as you might think your spouse is, that's probably not incurable insanity by the legal definition. Okay, so let's keep going. I'm going to scroll down, and you'll see we have the same questions on custody and visitation. I'm just going to gloss over this again. If you have questions on what those are, talk to me afterwards or go back and view the actual video on the petition. So in this case, let's say that Dale wants joint legal custody, but Dale actually wants sole physical custody of the kids. So we're going to check the box joint, and then Dale's going to check 9B, saying that Dale wants physical custody of the children. Go up one. So if you see B, okay, you want to check the box under respondent. So that's Dale is the respondent. We're filling out the response. So Dale is saying, I want sole physical custody of the kids. And in that case, then Dale would be saying petitioner, meaning Jamie would have visitation with the kids. So we'll check the box petitioner. Okay. And let's say Dale wants attorney fees. Okay, so this is a common mistake. Probably the knee-jerk reaction is to put respondent under attorney fees, but that's saying respondent wants to pay respondent's attorney fees. You don't want to do that, so that's a little bit opposite. So check the box petitioner. So Dale wants Jamie to pay for Dale's attorney fees. And then spousal support. If Dale wants spousal support, Dale would check the box F. Yep, other way. So that's saying that Jamie should get spousal support. Perfect. And Dale probably doesn't want to pay spousal support to Jamie. Then we'll check box G, saying that Dale does not want to pay spousal support to Jamie. So spousal support, it's one of those things where I don't think many people actually like to pay it. Some people might feel duty-bound to pay it or morally obligated to pay it, but I'm not sure anybody really genuinely likes to pay it. So just because you check the box doesn't mean you're going to get your way. There are a lot of legal reasons why you would need to pay spousal support or why you'd be entitled to spousal support. But that doesn't mean you don't have to tell the judge what your preference is. And again, we're going to check box H for the court to be able to determine property rights. And it's the same thing with regards to restoring a last name that I talked about in the petition. If you are the respondent and you have changed your name in the marriage and you want to change it back, that's totally fine. And it doesn't matter if you're the husband or the wife. If you want to restore a maiden name, let's say both of you hyphenated your name just as part of your marriage, you can both remove your hyphenations and go back to your maiden names. It doesn't matter, again, husband or wife. And you can do this. This is the one thing you can do at any time in the divorce process. It doesn't matter if it's now, it doesn't matter if it's later, it doesn't even matter if the divorce is finalized. But if you know now, you might as well put it in. All right, so let's keep going down. And you're going to print your name, date it, and sign it. And then you need to respond. As a respondent, you have 30 days from the date you are served to file your response. So it's a common misconception that if you don't respond within 30 days that something bad happens. No, nothing automatically happens, and nothing is automated about the court system. If it doesn't happen, it's up to the petitioner to do something about it. It's up to the respondent to do something about it. But my advice to all of you who are responding is get it done in 30 days, because if you don't do it, your spouse could do something and then it takes a lot of time to undo. And I won't go into all the legal technicalities of it, but please make sure to file your papers on time. So once this is done, you're just going to print it out, sign it, file it with the court. Just like the petitioner has to pay filing fees when they file for divorce, you also have to pay filing fees. So don't just think that, oh, well, I let my spouse do it so I don't have to pay anything. I'm sorry, they get you both. And right now the filing fees are $435. Contra Costa, most counties do accept both check, cash, and credit card, but if you have doubt, please call and make sure for credit cards beforehand, or else bring alternate form of payments. Okay, so we are going to take another quick break, and then we are going to go on to stage 2 of the divorce forms that we're going to cover tonight. Hi, I'm Cristin Lowe. Thank you very much for watching the video. I hope you found it helpful, and I hope that I was able to help you through this really difficult time in your life. I'd like to invite you to hit like or comment or subscribe to our video series. If you have any specific questions regarding the form or regarding the divorce process itself, please email me directly at Cristin@CristinLoweLaw.com. Thanks again.